Okay. Okay. Good morning, everyone. I'm attorney Victor Dicida. Uh, I will be responsible for the lecture on the subject role of law. So bear with me for maybe 3 hours to discuss to you the coverage of this subject. Now, the scope or the coverage of this subject, there are five major topics which we'll be discussing. First, the concept of the role of law. What is the role of law? Uh, what do you mean by role of law? Then we will be discussing the Bill of Rights, which is embodied in Article 3 of the 1987 Constitution. We will be discussing also the writ of habeas corpus, human rights, then followed by international humanitarian laws, which governs the laws on war or the laws during armed conflict. So first, we will be discussing rule of law. First, what do you mean by laws and the importance of having laws? And we will be discussing also the important principles under or you must remember under the concept of the role of law. So first, what do you mean by laws? When you speak of laws, these are set of rules or body of rules which a particular country or community recognizes as regulating the actions or movements of its members and which it may enforce by the imposition of penalties. In other words, violators are being brought to proper tribunal to answer for breaking the law or violations of the law. So laws govern much of what everyone does day in and day out. It tells us what our rights and duties are. It allows us to assert rights that we have. It lets us know the consequences of not doing what we are supposed to do. So, in other words, laws determine what should be our actions. Every person must be guided by law in each and every act he or she make. Now, the role of law is a principle of governance in which all persons, uh, foreigner or citizens sojourning in the territory of the Philippines, also institutions and entities, either public and private or government owned or privately owned, including the state itself, are accountable and are obliged to follow the laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights norms and standards. So there are some important principles that you must remember under the concept of the rule of law. Remember that Philippine government is a government of laws and not of men. Meaning to say that everyone or our government, what is being followed in the Philippines are the laws, not what is being commanded by those in position in the government. Number two, remember this: no one is above the law. Even the highest ranking official of the government, like the president of the Senate, the Speaker of the House, the justices of the Supreme Court, must act in accordance with the law. In the performance of their respective duties, their action must be in accordance or must conform to the existing laws. That is what you mean by rule of law. So laws must always prevail. Okay? Not the interests, not the wishes, not the wants of those sitting in the government. It must always be the laws that must be followed. That is what you mean by rule of law. Then you cannot invoke that you do not know the law, because ignorance of the law excuses no one from compliance therewith. So you cannot say that you do not know the law, you failed to read, or you failed to listen, you failed to hear the existence of this law. So you will be asking for an excuse. But the law says ignorance of the law excuses no one from compliance therewith. So even though you do not know that there is that law, you still be liable if you violate the said law. Now, we will come to the Bill of Rights. This is the provisions in the Constitution, particularly found in Article 3 of the 1987 Constitution. No? This is the formal declaration or enumeration of the fundamental rights of any person or individual, secured and guaranteed by the Constitution. So as law enforcers, government, or you are a member of government authorities implementing laws, you have to know all of these rights of an individual person guaranteed by the Constitution. Now, Section 1, Article 3 of 1987 Constitution. It says, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Section 1 of Article 3, 1987 Constitution speaks of two rights: the right to due process and the right to equal protection before the law. So what do you mean by right to due process? Before a person could be deprived of his life, meaning to say if he is sentenced to death and being deprived of his life, if he is being sentenced to imprisoned and he is being deprived of his liberty, or if his property is taken from him, the observance of due process must be needed. And what do you mean by this right to due process? Before he is being deprived of his life, liberty, or property, he must have given the opportunity to be heard before he is being condemned or being sentenced to death or to be imprisoned, or before his property is taken from him. So right to due process simply means the right or the opportunity to be heard before being sentenced to death, to be imprisoned, or deprivation of his property. So number two rights there, the right to equal protection or equal protection clause. It simply means that regardless of your sex, age, race, in the eyes of the law, you are equally protected. Okay? So in all of us, regardless of our sex, race, age, we will we in the eyes of the law, we are equal. Okay? So that is what you mean by equal protection before under the law. Walang mayaman, walang mahirap. Now, Section 2. Section 2 speaks of the right of the person against illegal search and illegal arrest. And what the Section 2 states, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. So it cannot be violated. And no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Now, please take note of this, that you cannot be searched in your positions, in your persons, in your body, in your house, in your cars, no? Whatever place you own, without any search warrant. Okay? In the absence of a search warrant, the search is illegal. And whatever items or illegal items that may be recovered from in your possession, that is illegally obtained evidence, and it could not be used in a case that may be filed against you, because it is not admissible, inadmissible in evidence against you. Okay? And also, you cannot be arrested without a warrant of arrest. So any person who will attempt to arrest you, you ask him here if she has a warrant of arrest. Now, please take note that these rights, anyway, all the rights here that being mentioned in the Bill of Rights are not absolute, no? There are, of course, exceptions to this right. Like, for example, the general rule is that, okay, let's go back. The general rule is that no person can be searched in his persons, houses, papers, and effects if the officer or any person conducting the search has or is not armed with a search warrant. But in some cases, search can be valid even there is no search warrant. Okay, like for example, a person walking on the street and a firearms is seen in his or is being tucked in his waistline, and it is in plain view. It can be seen in a plain view. Okay, so that person could be freezed by a law enforcers, Philippine National Police, NBI, or any law enforcers, and ask him of documents, like for example license of his firearms, license to carry. So if he could not present that, he can be arrested. So that is a typical example of an exception to circumstances wherein search cannot be done without search warrant. In some instances like this is what you call plain view doctrine, wherein a law enforcer or any citizen can search a person if the items, the illegal items per se is or can be seen in a plain view. Okay? And also, if for example, if a man is actually committing a crime, okay, an arresting officer immediately in arresting that person, because he was actually arrested while he is actually committing a crime, he can immediately be searched in his person immediately after the arrest. This is what you call a search incidental to a lawful arrest. Okay? So again, a person who is arrested because he is actually caught in the act of committing a crime, he can immediately be searched in his persons. His body could be searched immediately for any possible weapons that can be used against the arresting officer. So any illegal items that may be recovered from that person after his lawful arrest can be used against him. Okay, because the search, even though there is no search warrant, is still valid because it is a search incidental to a lawful arrest. Although the arresting officer or the officer who is conducting the search was not armed by a search warrant at the time of his search. Now we will come to the second right, no, right against illegal arrest. Please take note that you cannot. The general rule is that you cannot be arrested without a warrant of arrest. Please take note that warrant of arrest and search warrant are only issued by the court. Okay, no other agency, no other governmental office that can issue a warrant of arrest and a search warrant except only the judge or the court. After examining carefully the complainant and the witnesses he may produce during the application of a search warrant or warrant of arrest. Now, as what I have said, the general rule is you cannot be arrested without a warrant of arrest issued by the court. But there are some instances wherein you can be arrested even though the arresting person is not armed with warrant of arrest. Like for example, if a person to be arrested is actually committing a crime and you were there, the officer, the arresting officer was present and actually have personal knowledge that the person to be arrested is actually committing a crime or has just committed a crime. Okay, so he can be arrested. He is caught in flagrante. We call it caught in the act. So although the arresting officer has no warrant of arrest at the time, he can be arrested. So this is a lawful arrest, although in absence of a warrant of arrest issued by the court. So these are a search warrant and warrant of arrest. The right of the people against illegal arrest and against illegal searches and seizure. Now we will come to section 3 of the Bill of Rights. This is the right to privacy. Okay? The privacy of communications and correspondence shall be inviolable, except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. So, if somebody is calling you or talking with you, your conversation could not be tapped. It could not be recorded without your consent or without your permission. The mail matters that is being sent to you could not be opened or could not be x-rayed to determine the contents thereof. Okay? So this is the privacy of communication and correspondence. Now, if you are calling someone, any officer of the law that will use any gadget or any machines or whatever that will record your conversation with the other line on the other line, then he will be liable for a violation of anti-wiretapping law because of this your right to privacy. So any information, data, whatever that may be obtained in violation of your right to privacy of communication and correspondence cannot be used in evidence against you. For example, you are talking to your conspirator in the other line to kill somebody, and then the following day, the person you named in your conversation was killed. A law enforcer tapped your conversation. That conversation which he recorded could not be used to file or to convict you in court. No, it cannot be presented in evidence in order to prove that you were the one who killed that person mentioned in your conversation. So paragraph 2 here said that any evidence obtained in violation of this section 3 and the preceding section there in illegal search and illegal seizure are all inadmissible for any proceedings, not admissible as evidence in any court of law. Please take note of that. Now, we will come to section 4. Now, section 4, 5, and 6, these are prohibition regarding passage of a law. This is directive to the Congress. So, section 4, no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. So the Congress, our lawmaking body is the Congress, composed of the Senate and the House of Representatives, could not pass a law that would curtail, that would prevent the exercise of our freedom of expression or freedom to speak, or to prohibit the media, the TV or radio or any social media to express their opinions and to speak what they want. And also, you cannot prohibit the people to rally, to assemble in order to petition the government for whatever redress or whatever they are asking to the government. No? Because this right to peaceably to assemble and petition the government for redress of grievances are being guaranteed here in Section 4 of Article 3, 1987 Constitution. Now, please take note that Section 4, freedom of speech or of expression or of the press are not absolute. So, still, please take note that when this is a fundamental um, a principle, when your rights end when the rights of others begin. Okay, so while it is true that you have this freedom to speak, to express your opinion, but this right could not be used to destroy the reputation, the credibility, or integrity of another person. So we have a law on libel or cyber libel. Now, wherein if you use this freedom to speak, freedom of expression to damage reputation of another, then you could still be held liable for libel or cyber libel, and you cannot invoke this defense that this is my right, this is guaranteed in the Constitution, the freedom of speech. No, you cannot invoke that because this right is not absolute. Now, also, you cannot say during, for example, you are rallying, staging a rally, and you are now instigating the people to arm themselves to overthrow the government. So that is also punishable as sedition. So you cannot invoke this right that you have the right to peaceably to assemble and petition the government for redress of grievances when your utterances is not already within the scope of this freedom of expression or of freedom of speech. Now we will come to Section 5. It states, no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. So, freedom of religion. So you can establish your own religion. You can exercise your belief. Okay, and the government could not interfere, or in fact, they could not provides funds or any aid for the establishment of this religion. Okay, there is what you call separation of the church and the state. So the state, the government could not provide aid for the establishment or for the enjoyment of any religion. The free exercise and enjoyment of religious profession and worship without discrimination of preference shall forever be allowed. And also, the government or our Congress could not pass a law that would require before you could exercise civil or political rights, you are being required to be a member of this kind of church or religion. No? So, like for example, the Congress could not pass the law that only Protestant or Roman Catholic are allowed to vote for presidential election. They could not impose that kind of test or requirements for the exercise of civil or political rights. Section 6. The liberty of abode and of changing the same within the limits prescribed by law shall not be impaired. So this is the liberty, your freedom to choose where to reside. No? Liberty of abode. And you can choose of changing the same. Okay, so you have the right to choose where you want, the place where you want to establish your home or your family home or your house and to reside there. Also, this section 6 speak also the right to travel. So you have, the government could not prevent you, or anyone could not prevent you if you want to travel around the country. Now, please take note again that this is not absolute. You can be petitioned to, or you can be deprived or prevented from establishing your home, for example, in a place where it is already dangerous. Like for example, the place where you reside is already in the vicinity of a volcano which is about to erupt, or along the banks of the river which is already in the brinks of being washed out. Okay, so also you can be prevented from traveling in a certain place, like for example you want to go to Marawi City, which at the time was under siege. So the government could prevent you from going there by reason of security, public safety. You can also be prohibited from going out from your house because of pandemic, for example, by reason of public health. So the right to travel and the right to choose of the place where to reside are still subject to limitations that may be imposed by law. Now, section 7. The right of the people to information on matters of public concern shall be recognized. So this is a freedom of information. You have the right to access to official records and documents, papers pertaining to the official acts of the government, transactions or decisions, as well as to government research data used as basis for policy development. Well, of course, the law says this is subject to limitations as may be provided by law. So, what are the laws that prohibits you from accessing information now? While it is true that you have the freedom, you have this freedom of information, but we have a present law which is the Data Privacy Act, which prohibit some citizens to access private information pertaining to private persons. Like you cannot simply ask for a copy of the birth certificate of live birth, marriage contract of another person without their written consent. The statement of assets and liabilities of a public officer, you cannot simply ask for a copy of that without their written consent. So this freedom of information is still subject to the limitations provided by law, which is this Data Privacy Act. Section 8. The right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law, shall not be abridged. This is the right of the people to form organizations or associations. Okay? Either he is employed in government or in a private, this right can be exercised by them without limitation as long as the purposes of that organizations or unions, associations are not contrary to law. So the right to organize. Section 9, private property shall not be taken for public use without just compensation. So, in other words, even you own a certain property, parcels of land, still it can be taken by the government from you, provided it is for public use, and you should be paid just compensation, the exact value of your property before it could be taken from you. So the right to a just compensation. Section 10, no law impairing the obligations of contracts shall be passed. Okay? So if you have already, if there is no law yet passed before you entered into a contracts, you know the contracts, when you enter into a contracts, you create obligations, you create rights under the contracts, but the Congress could not pass a law that would impair, that would change the tenor, the terms and conditions of the contracts which you have already entered into before the passage of the law. So, although there is a law that will be passed, abridging or changing the terms and conditions of contracts, it should not affect the terms and conditions of the contracts which was already entered into prior to the passage of the law. Okay? Now, Section 11, free access to courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. So, Section 11 guaranteed here to the poor, to the right of any person to have a free access to the courts or any quasi-judicial bodies, although he cannot afford to pay the lawyer to the and to the filing fees that may be incurred in filing the case in court. So they are guaranteed here that they are free to file a case in court without paying anything. Okay? So we have now the government established or passed a law creating public attorney's office which aid any person, a poor person, shall we say, in filing a case and enforcing their rights, their claims, their interests. They are free to access the help of the courts without need of paying or spending much in asserting the rights in court. Now, Section 12, this is very important for any law enforcers, police, NBI, PDEA, and also members of the armed forces. If a person is under investigation, custodial investigation for an alleged commission of an offense, these are the rights of a person under interrogation or custodial investigation. That person under custodial investigation has the right to be informed of his right to remain silent, to have competent and independent counsel, preferably of his own choice. Okay? So if he cannot afford the services of a counselor or a lawyer, he must be provided with one by the government or by the law enforcer who custody him for interrogation. Okay? So this right to remain silent, to have counsel or lawyer shall not or cannot be waived except in the presence of a lawyer. Please take note of this. That is why when every time the police arrest a person, they immediately utter or speak these rights to the person arrested. Like for example, oh, you are hereby, the policeman usually made these utterances, make these utterances. Like for example, oh, you are hereby arrested for committing a crime, blah blah blah. So you have the right to remain silent. You have the right to have a lawyer of your own choice. But if you cannot afford, we will give you one. Okay? So anything that you missay or you misspeak here may be used against you. So better to remain silent until your lawyer uh, come to your aid. So the right to remain silent, to have lawyer, that is the basic right of a person under investigation. Now please take note, if a person is under investigation, no torture, force, violence, threat, intimidation, or in any other means which vitiate the free will of that person shall be used against him. Okay? Secret detention places, solitary, incommunicado, or other similar forms of detentions are prohibited. So the detention facilities, okay, should be known to the public, to the relatives, to the family members of the detainee. And the detainee or the person under custody should have an access to communicate to his lawyer, to his family. Okay. Any confession or admission obtained in violation of this or section 17 hereof shall be inadmissible in evidence. Like for example, the person under custody for investigation or under tactical investigation was tortured or was forced or physical violence was used to obtain information against him. All informations, all utterances he made admitting the crime to have admitting to have committed the crime, and it has been recorded, that admission or confession of commission of a crime cannot be used against him if it is already presented in court. That admission which was made through torture, force, violence, threat, or intimidation are not admissible in evidence in any court of law. Then the law shall provide, kinanglan, we have to pass a law for the penal and civil sanctions for violation of this section. Section 12. No? So any interrogating officer could be held liable for violating these rights of a person who is under tactical interrogation or custodial investigation. Section 13. All persons except those charged with offenses punishable by reclusion perpetua when evidence of guilt is strong shall, before conviction, be bailable. Okay, so this is the right to bail of any person charged of any crime or accused of a crime. Every person has the right to bail, except, according to section 13, those persons or accused being charged of a crime which is punishable by reclusion perpetua. This refers to heinous crime. Heinous crime usually, or definitely, they are punishable by life imprisonment. And when evidence of guilt is strong, they are they are prohibited or they are deprived of this right to post bail. So in other words, while their case are being tried, being heard in court, they could not go out, they could not post bail for their temporary liberty. So all other crimes other than those crimes which are punishable by reclusion perpetua are bailable. Okay? So meaning to say the bail, this is this is an amount or property. Okay? The bail refers to amount or property that is being delivered to the court for purposes of your or sa guarantee for your temporary liberty while your case is being heard in court. Now, Section 410. No person shall be held to answer for a criminal offense without due process of law. Now, recall Section 1 a while ago. No person shall be deprived of life, liberty, and property without due process of law. So the same is true that before a person could be sentenced to answer or to suffer a penalty for a criminal offense, they must be afforded due process of law. Due process of law simply means the right to be heard, or he must be given opportunity to be heard before he is sentenced either to death or deprivation of liberty or imprisonment, shall we say. In all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel. Okay, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have compulsory processes to secure the attendance of witnesses and the production of evidence in his behalf. Now, please take note of this. These are the rights given to a person accused of a crime. Okay? Kung akusado ka, ito ang mga rights nyo. First, the right to due process. Then, you are any person accused of a crime shall be presumed innocent until the contrary is proven. You have the right to be heard by a counsel, by a lawyer. You have the right to be informed of the nature and cause of the accusation against him. That's why before the start of the trial, there is what you call a portion arraignment. No? In arraignment, you are the accusation is being read to you. Ikaw, Juan de la Cruz, inakusahan ng pagpatay ganito noong nangyari noong March 21, 2020. So tapos tinatanong ka, do you plead guilty or not guilty? So that is in compliance of this right to be informed of the nature and cause of the accusation. Okay? That is a requirement of the Constitution. Before the start of the hearing, you must be informed of the nature and the cause of the accusation that is being filed against you, so that you can intelligently prepare for your defense. Okay? Then you have another right, speedy trial. So, justice delayed, according to them, justice denied. So, you must be given speedy trial as much as possible. Your case must be terminated within 90 days period and continuous speedy trial. Now, Section 15. The privilege of the writ of habeas corpus shall not be suspended except in cases of invasion or rebellion when the public safety requires it. What do you mean by privilege of the writ of habeas corpus? What do you mean by habeas corpus? There is a separate discussion to this uh, later in the later portion of this topic. Now, but the writ of habeas corpus, this is a legal action. No? This is a case which to be filed by a person who is under custody of any law enforcer. Gindetain siya o inaresto siya. He does not know what is the cause of his arrest, and he is just being detained. Then he can ask a lawyer to file a case in court for the issuance of this writ of habeas corpus. Petition the court for the issuance of a writ of habeas corpus. This is simply a case, an order to obtain an order of the court ordering that persons or officers of the law to produce you in court and explain. They will be asked by the court to explain in what will be the legal basis, what is the legal basis, what are the legal basis for your detention or for your arrest. So if the court could not find no sufficient basis for your detention made by the law enforcers, then the court could order your release from their custody. So this is a very important remedy that is provided by law, this writ of habeas corpus. Now, section 16, all persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. Now, as what I have said a while ago, justice delayed, justice denied. So persons accused of any crime or even administrative case, you could demand that your case will be terminated speedily. Okay? Because under section 16 of Article 3, 1987 Constitution, you have the right to a speedy disposition of your cases. Section 17, no person shall be compelled to be a witness against himself. This is a right against self-incrimination. So if you are being accused of a crime, you cannot be called to the witness stand if you do not want to take the witness stand, no, in a court. Because you have this right not to be compelled to testify against you. Okay, against your interest. Okay, this is what you call right against self-incrimination. Okay, you cannot incriminate yourself for the commission of a crime. Hindi mo pwede itumbok ang kaugalingon mo eh. Okay, so you could not be compelled to testify against yourself. Because on the first place, you have the right to remain silent. Okay? You cannot be compelled to speak. It is the burden of the persons who filed the case against you to prove your guilt. Okay? Section 18. No person shall be detained solely by reason of his political beliefs and aspiration. So, but until now, we still have political prisoners. Okay? So if you are a communist, if you are believers of a communist, the government would not detain you by reason of that political beliefs on a particular political ideologies. Okay? But if your political beliefs is against the existing laws of the Philippines and you put it into action, then you could be held liable. But political beliefs alone without violating or if you do not put it into action to violate existing laws, then you cannot be held liable. Okay? If you are believers of communism, but you did not take arms against the government to overthrow the government and to change it, the political systems you want to impose, then you could be held liable for rebellion. Okay, you are a rebel. But definitely, if you are just advocating political ideologies without any violating or putting it into actions, you could not be held liable. No involuntary servitude in any form shall exist except as a punishment for a crime where the parties shall have been duly convicted. What do we mean by involuntary servitude? This is slavery, whatever form. Okay? So, even though you have obtained a big amount of indebtedness to a particular person, you could not be compelled by him that you will just render services to him, because this is against the Constitution. Uh, this amount already to slavery, involuntary rendering service, involuntary servitude. So you cannot be compelled to render service to any particular person, okay, except, according to the law here, except if it is imposed by as a punishment for a crime where the parties shall have been duly convicted. Okay? Like for example, you are ordered by the court as a punishment to render community service. You clean the toilet, everyday public toilet in plaza or in market, public market, for 30 days. Is that involuntary servitude? No. According to law, Section 18 of the Constitution, it is a punishment for a crime which you have committed. Now, Section 19, excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Neither shall death penalty be imposed. That is why we do not have death penalty anymore, unless for any compelling reason involving heinous crimes like murder, rape. Okay? This can be restored back by Congress, no, in a law, to be passed by Congress. Any death penalty already imposed, okay, prior to the effectivity of this Constitution, last 1987, was reduced to reclusion perpetua or life imprisonment. Now, please take note, no cruel penalty that could not be imposed by the court. Example of cruel penalty, yung latigo. Okay? Latigohon for 1,000 times. So that is cruelty. It cannot be imposed here in Philippines. Degrading or inhuman punishment. Okay? A wife is found guilty to be guilty of adultery. He could not be made to have himself naked in public. Or a thief could not be forced to roam around the plaza, bringing him with the placards, "I am a thief." Okay? That is inhuman or degrading punishment. It cannot be imposed by any court of law. The employment of physical, psychological, or degrading punishment against any prisoner or detainee, or the use of substandard or inadequate penal facilities under subhuman conditions shall be dealt with by law. So, degrading punishment, employment of physical or psychological, like for example, mental torture, you are torturing mentally the prisoner. This shall be dealt with by law. Any law enforcers that doing this should be dealt by law. Section 20, no person shall be imprisoned for debt or non-payment of a poll tax. So walang may Walang pwedeng mapriso dahil sa utang. Okay, for non-payment of debt. But there are times that when you obtain a certain amount or funds or budget which is being entrusted to you, okay, for a particular purpose that is not a debt, if a money which you have obtained has an intended purpose, you have an instruction to pay this to somebody or pay the bills of the person who gave it to you, and you use it for your own personal consumption, then you are liable for estafa. Okay, any money or property that you receive from other person which was entrusted to you and you use it personally for your own consumption other than the purpose for which it was intended, then you will be liable for the crime of estafa and you may be imprisoned. This is not an ordinary debt. Okay, the debt here being referred to is a loan. Okay, a legitimate loan. Now, non-payment of a poll tax, so you cannot be imprisoned for not obtaining a cedula. Okay, poll tax is a resident certificate or community tax certificate. So if you have no cedula or community tax certificate, you cannot be imprisoned. Section 21. No person shall be twice put in jeopardy of punishment for the same offense. So if a particular act is punished by law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Like for example, a case of murder was already filed against you on the same victim, on the same incident, and you were acquitted later. The relatives of the victim could not file another case on the next following months or years for the same case, for the same act. Okay? Because this is already in violation of this provision in Section 21, wherein you will be put in double jeopardy. Okay? So you cannot be charged of a particular act, commission of a particular crime for or twice. Okay? After you have been acquitted, you cannot be charged again for the same offense. Section 22, no ex post facto law or bill of attainder shall be enacted. What do you mean by ex post facto law or and bill of attainder? This is directives to the Congress, our lawmaker who in charge for the passage of law, for the enactment of law. So the Section 22 said that Congress could not pass ex post facto law or bill of attainder. Now, ex post facto law is simply, this is a kind of law passed by Congress that punishes actions retroactively. Okay? Like for example, you have performed a certain or particular act on 2020, which at the time of the performance of that act was still illegal or there is no law yet punishing that act. But this 2021, the Congress passed a law punishing those acts which you have committed in 2020. That law is what you call ex post facto law. That is prohibited by Section 22. The Congress could not pass a law, the effectivity of which retroact in some in a previous time, wherein a particular act is still considered legal at the time of its commission, and it was later on declared illegal or considered already a crime subsequent to the performance of that particular act. So that kind of law is what you call ex post facto law. How about bill of attainder? The Congress also could not pass a law declaring a person or group of persons guilty of a crime without the benefit of giving them their day in court. Okay? So the law says, oh, whereas the peoples committed the issuance of a check should be declared, those people who issue the check today, which checks bounds later, should be guilty of a crime of estafa without need of court intervention, without need of hearing in court. So that is what you call bill of attainder. You are depriving a person your day in court or benefit of a hearing in court. Okay, it is also in violation of your right to due process, as what we have mentioned a while ago. Okay, now here is the another topic, scope of this coverage. We have mentioned this a while ago. A writ of habeas corpus. This is a legal remedy, a case that could be filed against a person, against a law enforcers, police, NBI, PDEA, or any person or any members of the military or AFP who arrested, detained a person, okay, without the benefit of a warrant of arrest. So, if you are a detainee in this typical example, without being charged in court for a violation of a crime or for a violation of a law, or without being charged of any crime, so what will be your remedy? You file a petition to the court for the issuance of this writ of habeas corpus. Habeas corpus simply means to have the body produced, or an order of the court to produce the person, the body of this petitioner, you as being detained. So the court will deliver this order to the person who is custody, or a person who are having a custody with your person. And at the same time, this order, this writ habeas corpus, has an order, has a portion there ordering this person having custody with you to explain what is the legal basis for his custody, for having a custody with you. So the court directs the person so detained to be brought before it, then examine the legality of his detention. So through the writ of habeas corpus, an order coming from the court to could be made possible, or it would facilitate the immediate release of the detainee or prisoner if the court finds out that the detention is without legal basis or without legal cause. So that is habeas corpus. Now we will come to human rights. Now, members of the military, the PNP, and other law enforcers are sometimes being charged of violation of human rights. What do you mean by human rights? All rights inherent to all human beings, of course, are called human rights. Now, human rights is an international claim. No? But is international human rights law recognized in the Philippines? Yes. By virtue of Section 2 of Article 2 of the Constitution, which specifically adopt, okay? So we are adopting, the Philippine government adopting the generally accepted principles of international law as part of the law of the land. So even though it is internationally promulgated, this is an international law, but it becomes a domestic law of the Philippines by reason of this incorporation clause of the Constitution found in Section 2 of Article 2 of the Constitution. So the Philippines adheres to international human rights law and conventions. The famous of which is the United Nations Universal Declaration of Human Rights, including the International Covenant on Civil and Political Rights. Now, the international human rights issues mentioned in the international community is likewise true or also an issue within the Philippines. So these are the international human rights issues. Like, for example, unlawful or arbitrary killings by the government security forces. Vigilantes, killing of by the vigilantes, another group allegedly connected to the government. And also killings made by insurgents or rebels. Forced disappearance, torture, arbitrary detention, harsh and life-threatening prison condition, political prisoners, okay, arbitrary or unlawful interference with privacy, killings of and threats against journalists, lawyers, prosecutors, and judges, government officials' abuse of power, human trafficking, the use of force and child labor, and terrorism. These are issues, okay, which involves human rights and are also true and happening in Philippines. Human rights. Why there is a human rights? What is the roots of this human rights violations? Now, it is believed that many of our disgruntled countrymen, okay, most especially the rebels, the present rebels like NPA, what else, so MILF, MNLF. So generally, they generally engage in lawless activities and eventually join dissident groups when their rights as human beings are violated. Okay? The cycle of rebellion and violent expression of dissent will never end if in the conflict environment the government troops and law enforcers do not respect the rights of the people. So sometimes our government troops, law enforcers, the PNP, can be said the major recruiter of rebels because sometimes they are the one who violated the human rights of these people, no, who become rebels. Okay. Now, how can we achieve how can we address this human rights problem? Now, there are some suggested goals here on how to address problems on human rights. Following are the means that countries in the international community commonly adopt to promote the observance of human rights in their countries. Okay, so these are practices in the international community, and of course we are also adopting this as a solution to the problems. Now, first, setting the example. A country that advocates the observance of human rights believes that its own human rights record will serve as an example for other countries to follow. So every time there is a convention, a UN convention, for example, in UN General Assembly, each of the country participants or members of the United Nations are reporting, okay, about their activities, the best practices, which they observe in addressing their human rights problem. So it is being shared by with the other member states. Diplomatic initiatives. Okay, our ambassadors, consuls, okay, and other diplomatic representatives in other countries, so usually they meet, okay, they talk informally and discuss important human rights concerns, okay, during their private meetings. And it is the activities, the programs of the other countries are being also replicated and observed in our country. Providing asylum to political refugees. So, political refugees. Most countries have immigration laws, of course, like Philippines. So, persons fleeing in their homelands due to persecution in the count of cultural, religious, and political beliefs may seek refuge in another state. Okay? But as a general rule, any foreign national who flees his country will not be granted asylum. Okay? He may, however, granted a temporary refuge if his life or safety is in immediate danger. So, in fact, during the uh, what call this takeover of Taliban in of Afghanistan, the Philippine government offered asylum to Africans refugees. So, the Philippine government is willing to accommodate this political asylum. Anyway, another solution being offered, pressure of word opinion. Now, for example, if one country failed to address his or continues to violate human rights, okay, and it's being reported internationally, these violations of human rights in a particular country, the member states of the United Nations could issue an official statement condemning such a country, and all other countries will do the same. So this is a sort of a pressure to that country, okay, about the word opinion. This is to the official statement that could be released by any country against a certain country that is violating human rights of their citizen would be pressured to succumb to word opinion. Okay? So a country who refuses to implement human rights and provisions of international law in their country may be condemned by another states or several states in order that a word a word bad opinion will be established against that country, the reputation of that country, the leaders of the country will be under pressure. Suspension of foreign assistance. For example, a country continue to violate human rights of their citizen. Any countries, like for example the United States, the European Union, who are giving such economic aid in that particular country, could withhold or could cut that aid in order that country will succumb to the demand of the international community for him to follow the human rights or the international humanitarian law. So suspension of foreign assistance or foreign aid. Implementation of economic sanctions. Countries that are unsatisfied with the consistently appalling record human rights violations of a particular country may reduce or terminate economic relations with that country. Like for example, if one country or two countries have an economic have a trade agreement, okay, so any country who which has an economic trade relations with that country which continues to violate human rights of its citizen could terminate such uh, economic trade or economic relations with that country as a part of economic sanctions of that states which continues to violate human rights of its citizen. Actions of United Nations and regional organizations. So United Nations could also impose, uh, like for example, the General Assembly of the United Nations, the member states could pass a resolution condemning such country who continue to violate human rights within his country. Or regional organization, like for example ASEAN, which Philippines is a member, association of ASEAN, Association of Southeast Asian Nation, so regional organization, could impose sanction to Myanmar, for example, which was the civilian government was taken over by the military through a coup, and and the existence of human rights violations there continues. Now we will come to international humanitarian law. What do you mean by this international humanitarian law? An international humanitarian law is a set of rules which seek for humanitarian reasons to limit the effects of armed conflict. It protects persons who are not or are no longer participating in the hostilities and restricts the means and methods of warfare. So international humanitarian law applies to armed conflicts or where there is war. Okay? That is why international humanitarian law is also known as the law of war or the law of armed conflict, because the international humanitarian law are laws that is being observed in the conduct of war. Okay? So what are the sources of this international humanitarian law? It may be derived from agreements between states, like for example, treaties and convention. Okay, we have Geneva Conventions. There are 4 conventions there held in Geneva containing this international humanitarian law. Also, it may be a sort of customary rules which just evolved, no, during war, which consist maybe of state practice considered by them as legally binding, and in general principles. Example, the principle of humanity will dictates of public conscience. Okay, during war, well, we cannot deny that some uh, combatants are also a human being, and treatment of enemy, uh, being human, they also felt pity on their enemies. So it is a dictate of public or their own conscience. So, so what are the covenants or conventions or treaties where you can find this international humanitarian law. So a major part of international humanitarian law is contained in the four Geneva Conventions of 1949. Okay, immediately after the World War II. Nearly every state in the world has agreed to be bound by them. Okay, the four Geneva Conventions of 1949 provides for the protection of victims of war. That is, number one, the first Geneva Convention, protection of wounded and sick on land. The second Geneva Convention, protection of wounded, sick, and shipwrecked at sea. The third Geneva Convention, treatment of prisoners of war, or POW. The fourth Geneva Convention, protection of civilians in times of war. Okay? So in other words, in short, these four Geneva Conventions of 1949 focus on the protection of the victims of war. The conventions have been developed and supplemented by two further agreements. So there are two additional agreements here. The first, the additional protocols of 1977 relating to the protection of victims of armed conflicts. And the other one, the other agreements prohibit the use of certain weapons and military tactics and protect certain categories of people and goods. This agreement include the 1972 biological weapons. Biological weapons are now prohibited. 1980 conventional weapons convention and its 5 protocols. So only conventional weapons are allowed. 1993 chemical weapons convention. So another chemical weapons are not allowed. The 1997 Ottawa Convention on anti-personnel mines, like anti-personnel, like booby traps, or what do you call that, the land mines, no? Where does not distinguish combatants or non-combatants. Whoever uh, can incidentally touch these mines, land mines, they might be the victims of these weapons. Okay, what does international humanitarian law cover? As what I have said, international humanitarian law are being observed during the conduct of war. Okay, being observed during armed conflict. So there are two areas wherein international law covers. First, the protection of those who are not, okay, who are not fighting, not non-combatants, okay, like, for example, medical workers, members of the Red Cross, members of the Red Crescent, or civilians who were what will is trapped in between the conflict, or those combatants are also covered by this humanitarian law, but combatants who are no longer taking part in fighting by reason of maybe wounded or become a prisoners of war. So they are covered by this international humanitarian law. Then the second is restrictions on the means of warfare. Okay? Means of warfare. Hiluan mong tubig nila na ilimnan. So that is prohibited. Or the use of a particular weapons. Weapons of mass destructions. Like, for example, the biological weapons, chemical weapons, okay, and the methods of warfare such as military tactics. No? The commander here has to make their operational plan, their military tactics conform to the existing international humanitarian law. Now, who are protected under IHL? International humanitarian law protects those who do not take part in the fighting, non-combatants, such as civilians and medical and religious military personnel. It also protects those who have ceased to take part, meaning combatants originally, but because wounded, shipwrecked, and sick combatants, and of course, combatants who become prisoners of war, captured. Okay. So international humanitarian laws should be taught to all the armed forces of the different countries. Okay, if your country, like Philippine state, because Philippines is a member of that conventions, Geneva Conventions, the Philippine state has a state responsibility to teach, to disseminate these laws of war or these international humanitarian laws, and to be part of the subject orientation of any members of the armed forces. Okay, so the law of war reflects an attempt by nations to establish a certain minimum standards of conduct by parties to an armed conflicts that will alleviate the suffering of victims affected by the fighting. So in other words, the war now at present is more humane compared to World War One and World War Two. Yeah. Such standards of behavior have been laid down in international treaties and accepted by virtually all the states forming the international community. The states parties to that treaties, to that convention, Geneva Convention, are bound to respect and to ensure respect for these rules in all circumstances. In order to fulfill such obligations, the state has, first of all, to disseminate the contents of this legal provision. So that is why you are being taught of these international humanitarian laws. The subject is forming part of your subject because it is in compliance with the state responsibility of the Philippines being a member of that convention, the Geneva Convention. So it has further to undertake to enact any legislation necessary to provide effective penal sanctions for persons committing or ordering the commission of grave breaches of the law of war. So aside from this disseminating these international humanitarian laws, the Philippine government undertakes also to legislate, to enact laws to provide effective penal sanctions for any members of the armed forces, of its armed forces, for committing or ordering the commission of these grave breaches of the laws of war or the international humanitarian laws. Now, there are 5 fundamental principles of the laws of war. So if you are a commander in the battlefield, you must think of these 5 before making a decision or in making an operation plan. You must take into consideration of these 5 fundamental principles. Now, military necessity. Is there really a need for a military to go on war? What are the suffering, unnecessary suffering that could be avoided, okay, in formulating your military tactics? You have to incorporate this in the formulation of your operational plan to avoid sufferings, the unnecessary sufferings of possible victims, especially civilians or non-combatants, medical workers. Now, proportionality. The principles of proportionality. Sometimes you have to, as a commander, you have to use weapons only which is proportionate. The effect or the degree of effect of that weapons is just proportionate to the uh, circumstances of enemies. No, what I mean is that you need not, if you have just sent 20 enemies in a camp, you need not to use guided missiles. Huh? It is overkill maybe, so it is unproportional. The degree of result may be unproportional to the weapons which you are using. Distinction. So you must use a weapon which you can easily distinguish your target away from the possible victims, which is might not be included, no, as your target, really not really your target. So you could not simply make a sporadic or indiscriminate attack. And honor. Okay, all militaries, even your enemies, has also an honor. We call it chivalry, which you have to respect. So law of war versus military necessity. So this is what one of the a while ago fundamental principles of international humanitarian law. So before a commander, now you know the role of the armed forces now has greatly changed now. A matter of fact, their main function is to prevent war. Can you imagine that? Through dissuasion. So as much as possible, a commander should choose not to go on war. But if war could not be avoided to break out, the commander has the duty to keep the conflict under control and try to prevent its escalation. Na magdako pa, no? No armed conflict can be humanitarian. Okay? When you speak of armed conflict, when you speak of war, it is, you cannot assure that war can still observe humanitarian consideration, no? Because it is war. In the best of cases, an armed conflict can be conducted rationally, meaning professionally, by respecting the tactical principles within the framework of the law of war. So this is very difficult, or a very difficult task on the part of the commander to formulate his tactical principles, the strategy, which must conform to the laws of war. The respect of the law of war and its role is not only a dictate of common sense, but the most important tool at the disposal of the military commander to avoid chaos. So as much as possible, the commander has to think, is there any necessity to go on war, military necessity? Then tactics versus the law of war. Now if war could not be avoided, and the commander has to formulate now his tactics upon receiving orders from his higher commander. So the tactics that should be formulated by the commander now must conform to the law of war. So tactics versus the law of war. So the commander here must bear in mind that the law of armed conflicts, the law of war, or this international humanitarian law should not be an obstacle, to his efficiency, to his if the, to the efficiency of his troops. He must situate that the law of war and his tactical principles are compatible. Now, what are these military tactics that a commander have to take? Okay, these tactical principles are as follows. Number one, annihilation of the enemy. So, this is your objective, to exterminate the enemy. Are you really determined to kill all of them? This principle must be considered with regard to the mission received. Okay? What will be the consequences of total destruction from the military and from the humanitarian point of view? Okay? Is there really a need for a total destruction? Or you have to consider humanitarian consideration? Annihilation of the enemy or extermination of the enemy very often means to render the enemy incapable of operating tactically. So it's just enough that your enemy was rendered incapable of operating tactically. Okay? The desired degree of destruction must therefore be determined in relation to the advantages and disadvantages of the effects on one's own liberty of maneuver. So this is known as the principle of proportionality. So when you're making an attack, you have to calculate. You have this estimation of how or how big the destruction that may be created. Now, simplicity of action. So, a commander must form an action plan which is simple. A complicated planning bears the risk of failure. So, in relation of the law of war, this complicated plan means result of unnecessary victims. Okay? So, concentration of forces. All tactical action has to aim at one's precisely determined goal specified in the mission. So, through appropriate intelligence, okay, data, concentration of civilians and other protected persons and other objects must be detected in parallel with the detection of rewarding military objectives. So, before you made an attack, so you have to equip yourself with information where these civilians are concentrated, the location of these protected persons and other cultural facilities like church. So you must determine there. Attacking non-military objectives is a waste of resources that could have been used in the main effort. So you have to preferably to attack only military objectives. Okay, it would be unuseful or a waste of time, a waste of resources to include non-military objectives in your attack. Unity of action. Every tactical action has to be part of an overall general plans. Okay? So there must be a unity of action. One movement for every troops. Bad planning means areas of friction that will jeopardize the success of the operation and results in casualties that would have been avoided. So there must be a proper planning or port. Liberty of maneuver. Liberty of maneuver means to keep the initiative. If it can be preserved, it will force the enemy to react according to one's own intention. So thus, therefore, one means will be protected. Surprise, okay, the elements of surprise increases the chances of success, and a surprise enemy is more likely to surrender, perhaps even without resistance. Okay, so why make an attack on the in the daylight wherein they are awake and ready to fight compared to an enemy, the conduct of an attack on 1 o'clock in the morning, okay, to surprise the enemy while they are resting. Okay, so they are unprepared, and they are caught in surprise, and they will be forced to surrender, thereby eliminating a strong resistance or a strong firefight to avoid more victims and distractions. Adaptation of actions to space and terrain. Okay, as part of the operation plan, you have to choose the proper terrain wherein you can shield or camouflage while you are taking movements towards the enemy lines. And of course, you take into consideration the passage, okay, the area where your men have to pass through in going to the objectives, because there might be several civilians and non-combatants that may trap during the battle. Now, economy of means. Well, war is, of course, war means limited resources. So, as much as possible, you observe economy. Attacks that are not directed against military objectives are often war crimes and the waste of men. So, preferred make a choice that you just attack only military facilities of the enemies. Okay? Security. Security, an overall principle, covers from the law of war point of view more those persons and objectives do not contribute to the military effort. Every responsible commander has an active responsibility not only to protect one's own men but also non-involved persons and objects and core and of course war victims. So you have to secure uh, other persons not involved in the battle. Okay. Now, dissemination of the laws of war. This is what I have said. I was mentioning a while ago that this is a national obligation of the member state, a state who are members, which are members of that convention of Geneva Convention. So they have, as a member of that Geneva Convention, there is an obligation, responsibility of member state to disseminate informations, knowledge about these laws of war. Because knowledge, it is the law can only be respected if it is known. Okay, you cannot expect somebody to respect these laws on war if they have no knowledge or information as to the existence of these laws. Throughout history, acts of great cruelty have been committed in war. Okay? That is admitted, like for example, massacres, torture, rape, pillage, summary executions. This happens during war. The necessity of canalizing and setting limits to barbarity has therefore always existed. The destructive power of technically highly sophisticated weapons and the existence of particularly odious means of warfare, example, biological and bacteriological arms, booby traps, etc., landmines, makes the necessity more urgent than ever. Okay? These are very destructive weapons. No? Weapons of mass destructions without distinctions. Combatants and non-combatants may be affected. Now, the law of war teaching file. The purpose of this teaching file is to provide the instructor who is to take up the instruction of the law of war with some basic texts, documents, and exercises which hopefully will help him in his task. Okay, the instructions aim at is battalion at the battalion level and below, company, platoon, and squad. The whole instruction program is based on the concept that a practical approach towards the subject matter is indispensable if immediate and measurable results are to be gained. The trainees have to feel that what is taught and instructed is applicable in real life and does not merely consist of empty humanitarian rules, which, although an integral part of mankind's cultural and philosophical background, cannot be implemented in combat situations. So do not think that this is just a mere on paper, okay? But this form part an integral part of mankind's cultural and philosophical background. Okay, now what are the distinction? How do you differentiate international human rights versus international humanitarian law? A while ago, we talked about human rights, and the last portion is the humanitarian law. Now, international humanitarian law and international human rights are two distinct but complementary bodies of law. Okay? They are both concerned with the protection of life, health, and dignity. However, international humanitarian laws applies in armed conflict. This is considered a laws to be observed in the conduct of war. While on the other hand, human rights law applies at all times. Okay? Either in peace or both in peace and in war. Okay? Because human beings, even he is an enemy, and in times of war, still he has a human rights. So in both peace, in times of peace and in war, still human rights law are being observed. But international human rights law, humanitarian law, are being observed only in times of armed conflict. Okay? Okay, that would be the end. I thank you very much for your time.